Hello, students. This is the video lecture for Chapter 6, Protecting Privacy. Can you see that? The framing looks a little bit different. The shot looks a little bit different because I'm just using my laptop. I've got this big monitor. I just decided didn't want to connect it to the monitor. All right, let's do this. Protecting Privacy, JMS 494. There is no right to privacy literally enshrined in the Constitution, but that has been derived from the Fourth Amendment, okay, which says specifically the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, okay? So working from this, and you see the mention of probable cause there, probable cause is necessary for police to get a search warrant for your property. From this Fourth Amendment right, the right to privacy has been sort of inferred and expanded, and it's kind of an ongoing evolution. The right to privacy is sort of ongoing. And right now, believe it or not, the FTC, Federal Trade Commission, is sort of the main government agency that is responsible for taking care of people's privacy, especially when it comes to data collection and how advertisers and marketers can use that information about you. Now, before we get into it, I just wanted to throw this up on the screen. Maybe I have to move this, huh? Yeah, okay. Bob Saget, I assume most of y'all, or maybe many of y'all, know who Bob Saget was, a comedian. Apparently he was rather vulgar on stage, but also the father in Full House. And he passed away recently, I mean, at least as of this recording, kind of unexpected. And the autopsy revealed about how he had died, and the judge blocked the release of the autopsy records, partially to protect the family, but also just the right to privacy. The right to privacy was sort of used as an argument that, you know, the public doesn't need to know the gory details about how this man passed away. And I kind of agree with that. You know, I kind of think we should respect the family and take care of the family's wishes. Even though there is a constitutional right to privacy, some things the courts have said were okay. For example, search of a public employee's desk and filing cabinet is not a violation. Again, this is a public employee, not people who work for private corporations. New technologies present all sorts of challenges. We mentioned this when we talked about the First Amendment. You know, all these new apps and new social media applications and things like smart speakers, and those even like, you know, those talking GPS devices or whatever in your car. All of these things have potential to record and pass on that information. So the courts are really, really struggling with how to deal with all these sort of new technologies. But the courts have found that the Fourth Amendment does protect CSLI, cell phone site location. I believe that's what it stands for, something like that. So when you're moving around with a mobile device, a cell phone, I assume y'all know, you know, whatever company you're with or network you're with has to track you to know which tower to ping the little signal off of. That's necessary for your mobile device to function. The police don't necessarily have a right to get that information. I assume if they have probable cause, they could get that information, but it's not considered, you know, public information. Now, there are different types of privacy torts, as we've talked before. A tort is some type of civil wrongdoing. The textbook organizes these privacy violations according to intrusion, false light, appropriation, private facts. And the status of intrusion torts is different in different states. I think it's true for everything in this class, Different states have different rules, okay? And if you are fortunate enough, well, I'm not going to say fortunate enough, you are all, inshallah, going to get great jobs. Inshallah, all of you are going to get great jobs, but they may not be in California, maybe not even in the United States. So wherever you're living, seek out and look up and find out whatever media laws and regulations apply to your specific line of work, whether it's advertising, public relations, whatever it is, journalism, of course. Find out what the laws are. All right, intrusion, or also known as intrusion upon seclusion, okay? If a reasonable person, and again, this is a term that's used many times in the law. What is a reasonable person? But let's just use common sense. If you are in a situation where a reasonable person should expect privacy, then there could be some violation, right? If you are in a situation where a reasonable person would expect privacy, you can, expect privacy. And intrusion on private property, if you're walking down the street, and you walk by someone's house and the door is open and you happen to see something, that's fine. If you cross into private property, go up to the window, press your face against the window, peek in, maybe use a camera to take a photo, that's clearly a violation. Because that person inside should have an expectation of privacy if they're in their own house, right? If they're in their own house. Now, things in public, I just mentioned, generally don't have an expectation of privacy, but there are exceptions. If a person was in an auto accident, for example, and is on the side of the road talking to a police officer or a EMT technician or something like that, news crew might show up, wants to get video of the car crash, right? Because people love car crashes. That person who's off to the side talking to the police officer or the doctor, I think has an expectation of privacy. They didn't intend to get into the auto accident. Whatever they're talking about is probably private. Okay. So you have to sort of evaluate everything on a case-by-case basis. If you have a laptop open at Starbucks here on campus, if you're in public, you got the laptop open, you have something on your screen, and someone walks behind you, I think it's, they're not violating your privacy if they just look over. If you're in your dorm room or your apartment and someone using a telephoto lens to peek in through the window, that's different, right? So I think everything has to be judged by case by case basis. But again, we use this sort of reasonable person logic. Now, the defense, if you are accused of violating someone's privacy by intrusion, consent is the only defense, right? If someone agreed to let you in, that's the only defense. There are some other mitigating factors. A story's newsworthiness might be a defense. If it's something that's really compelling, it might be a defense. And you are allowed to use false pretenses to enter a property in some cases. You cannot ever pretend to be a police officer. That is a big no-no. Do not ever pretend to be a police officer. But I think it's in the textbook, some journalists claim to have some sort of medical condition to get inside a medical facility. That was considered to be okay, because I guess whatever the particular story was, that was considered to be okay. And then later in another lecture, we'll talk about the Food Lion case, where some reporters lied and pretended to be different people in order to get jobs at a grocery store. That was not considered to be okay. So again, I think we have this case by case basis, but you can at times use a false pretense to enter a property. Now, false light, I don't really totally understand this. I'm just going to be honest. I'm the professor, but I don't understand this. It's the first cousin to libel. It's not even recognized in all states. I don't know the difference between false light and libel. Okay, just being honest here. Good thing we're not having any essay exam about this. In certain states, the media defendants can use the libel defenses, the same defenses you might use to get out of a libel situation, you could also use for this. And again, the anti-SLAPP statutes apply to false light as well, which we talked about when we talked about libel. So just know that false light is very, very comparable to libel, attributing comments to someone that someone didn't make or portraying them in some way that they feel is defamatory. Appropriation. Okay, we have two different things under appropriation: commercialization and the right of publicity. They differ in two important ways. Basically, the idea here is, now think about celebrities. Okay, you're using a celebrity's image or likeness for some type of commercial purpose or without their permission. Okay, but the difference between commercialization and the right of publicity: commercialization protects an individual's dignity connected with personal privacy, while the right of publicity protects the monetary value of using a person's name and pictures. Okay, So commercialization is just about their personal privacy. Right of publicity has to do with financial gain. I think this next difference is more important. Courts generally consider commercialization a personal right, one that does not survive a person's death. So the right, the privacy connected to commercialization ends with someone's death, but the right of publicity extends afterwards. Now, there's been many, many legal disputes, and they are intensifying when it comes to deceased individuals, like, images of Prince, Whitney Houston, Michael Jackson, Robin Williams. Okay. These are all, famous people. You can't, or you shouldn't anyway, use their likeness without the estate's permission or the family's permission, even after, they're gone from this planet. And even if you change a little bit, if you change someone's likeness significantly, that's okay. But if you change a little bit, that still cannot be okay. It still cannot be okay. Like using sort of the lookalike, and you have a Bruno Mars lookalike. Well, it's not really Bruno Mars, but it looks like Bruno Mars, and everyone in the audience is going to know that you're pretending it's Bruno Mars. That could be a problem. Again, even if you're not using the entirety, if you're using the name, a likeness, sound alike voice, or some sort of computer generated replica, like you come out with a video game that has Travis Scott was in Fortnite, right? Okay, I mean, I don't know if he's still around, whatever. But Fortnite couldn't have used a Travis Scott lookalike without Travis Scott participating. They couldn't just say, hey, we got a new skin, and the new skin looks exactly like Travis Scott, or someone else. Now this, I don't know how, pardon my language, I don't know how in the heck Hasbro thought they could get away with this. There's Harris Faulkner on the left. She's a news commentator on Fox News. Hasbro came out with this little toy. It must have been part of a line of cute little animals or something like that. It's a hamster. The name of the hamster is Harris Faulkner. That's literally her name. It's not even like Ferris Faulkner. They didn't change it a little bit. Harris Faulkner on the left. That little hamster is also called Harris Faulkner. How did Hasbro think they were going to get away with it? They had to settle out of court because that's clearly an appropriation of, someone's name. Not really likeness, but appropriation of someone's name. Okay, now this case is an interesting one. It makes me laugh. Cheers was a sitcom, very, very funny sitcom. Frasier was a spinoff from Cheers. That's not on the exam, but Frasier was a spinoff of Cheers. Cheers is set in a bar. There's two characters. Norm is the character. I don't know I'm blanking on the actor's real name, but Norm is the top left. Cliff is the top right here. Two characters, they sit at the edge of the bar every episode telling jokes. Someone buys the rights to open some bars in airports. They have bars in airports. Every airport has a bar, sometimes multiple bars. The bars were going to be called Cheers. Okay. And inside the bars, they had these animatronic robots that look hideous, right? But those two robots sitting at the edge of the bar, these actors claim that that's an appropriation of my likeness. Now, granted, they're hideous looking robots, but I do think that they have a case, or they did have a case, that anyone who knows the show Cheers, you walk into a Cheers themed bar in an airport, you see these two robots at the edge of the bar, your first association is, oh, that's Norm and Cliff. Okay. So even though the people opening the bars had gotten the rights from the studio, they had not gotten the rights from the actors. So they actually lost that case. And I've never seen a Cheers themed bar in an airport, and I have flown many times. Now, here are all the defenses that you could use if you are accused of appropriation. I'm not going to read through them. They're in the textbook. Y'all can read. But do take a look at this one here, the transformative use. I mentioned that, a transformative use test, okay? If you take an existing person and modify their likeness just enough, I don't know what just enough is, but if you modify it enough, that can be considered transformative and you will get away. Here are some real life incidents. Tony Twist was a hockey player. I'm sure that was his nickname, not his real name. He was known as an enforcer. This is a term in hockey for people who fight. Maybe you bump one player a little too much, the enforcer is going to come over and, take it out on you. Tony Twist was an enforcer in hockey. As part of the Spawn franchise, that comic book series, they came out with this mob enforcer named Tony Twist. Same name, exactly the same name, similar kind of theme. And in this case, the real Tony Twist won, got $5 million. They settled out of court, but I think Todd McFarlane, isn't he the guy behind Spawn? I think he knew he was going to lose the case, so he just settled out of court for $5 million. However, in this comic book case, this is from Jonah Hex. Jonah Hex is a horror comic book, a horror-themed Western comic book, okay? A horror-themed Western comic book. There was these two characters, last name Autumn. They were the Autumn brothers. They're the Autumn brothers on the bottom. They look very, very much like Johnny and Edgar Winter. They were two real musicians. They were albinos, so they, had a very distinctive look. Let's say they were albino musicians. Last name Winter. In Jonah Hex, we have the last name Autumn. Big difference. In this instance, the courts found that was a transformative use. So the Jonah Hex series was allowed to use the Autumn brothers. I don't think it's that transformative, but whatever. Now we have the private facts, okay? If someone publishes information about you that you don't want known, okay, this can be considered a violation of your privacy. And there's different kind of intimate facts you might not want known. Maybe it's medical condition, maybe it's your sexual activities, your financial condition. There could be many things that you don't want publicized. And if a news reporter or a media outlet decides to use that information, they could be responsible for violating your privacy. And there could be some financial compensation associated with that. Here's probably the most famous case, or very, very famous, not say most famous, very famous. This guy, Oliver Sipple, sometimes known as Billy Sipple, saved the life of President Ford. This is in 1975, okay? President Ford, he was the only president never actually elected. He was the only president never actually elected. He became vice president to Nixon when Spiro Agnew had to resign. Ford was appointed, and then when Nixon gave up his job, he was being impeached, Ford became president, so he's never actually elected. Whatever, little historical anecdote there. Anyway, this woman extends her arms, going to shoot President Ford. Sipple, who was a former Marine, just happened to be nearby, reaches out, knocks the gun down, presumably saves President Ford's life, okay? Saves his life. Well, Sipple was also gay. Yeah. And the reports came out that he was gay, and this was all over the news. He was not totally open. Apparently, some people in the San Francisco community knew that he was gay, but his family did not. And I think even in the 21st century, whether or not you want to be public and out about your sexual identity is a personal decision for each person. And it can be, somewhat tense depending upon where you are, what your job is, where you live. You have to imagine in 1975, the situation was even more drastic. Okay, that was really something that, if you wanted to keep private, you should be able to keep it private. I don't think it had anything to do with him saving the president's life. I don't see how that is relevant whatsoever. Maybe him being an ex-Marine, maybe that's relevant. He knows how to respond well under pressure. Maybe that's relevant, but his sexual identity has nothing to do with it, at all. And he tried suing and never was able to win anything. He never was able to win anything. If you are wanting to defend yourself, okay, and you claim your privacy has been violated, if the courts find that the story is so newsworthy and it's a matter of legitimate public concern, then the public has a right to know about it, right? The public has a right to know about it. Or if the information, the private information, if it came from some type of public record, then again, that's okay. If it's in a public record, You would say it's not really private. It's already been revealed to the public. Okay. For example, in the case of Sipple, if Sipple had marched in a gay pride parade, just as an example, or maybe given some big interviews to local magazines in San Francisco, like, yeah, I'm gay and I'm proud and I'm out. If he had done that, then when the press later reported it, they would say this is already public information. It's already been revealed. But he had not done that. Okay. It was not a matter of public record. So if something is a matter of public concern, it can be revealed. And I'll end here with the discussion of privacy and data protection. Again, the FTC, Federal Trade Commission, is responsible for enforcing these federal privacy laws. And I know that, you're all smart SDSU students, and, you know about online privacy and cookies and how your behavior is tracked. So much information is gathered about you, and it's bought and sold, sometimes by third parties. It could be sold many, many times. And sometimes people cross the line and gather private information that they should not. But many times when you're signing up for a social media website or downloading an app or whatever, you are unknowingly agreeing to allow your information to be tracked like that. So over the years, and even within the past year, there have been changes and changes made to kind of cut down on this. And the FTC has said for a long, long time that we don't have strong enough privacy laws. All right. That's it. I think I like this angle better. I think you can see me better. I don't know. I think I like this angle better. Anyway, that's it. Bye.